You all can't enter into a plea bargain agreement telling the court what your conditions will be.
That is not my understanding of the practice in this county.
Well, if people are practicing that different in this county, and then they are practicing the law incorrectly because the court decides the length of probation.
It's been my understanding and the practice in this county that the judges allow us to do that.
Well, I don't want to disparage any judge, but guess what? They're wrong.
Correct.
All right, defense counsel says there's been some issues with the GPS device. Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record.
Julio Garza.
All right, Mr. Garza, are you the pretrial services officer for Luz Eduardo Briceño?
Yes, Your Honor.
All right, so these are the issues and this is what I'm being told. I really don't deal in hyperbole. I just want the facts. So I'm being told that Mr. Briceño has employment. He works construction. And in the defense's motion, it says all hours of the night and required traveling depending on the jobs. All right, we're not going to do the all hours of the night. What I want to know is if he's given a set time where he can be out on employment. Are you going to be able to follow through on that, or do you need him to call in to say he's working employment?
So he would have to provide us the already set schedule for employment.
All right, so here's the deal. It's construction. Usually they don't have a set schedule. And this is from my background in dealing with construction workers and doing a little bit construction myself.
Mm-hmm.
You don't know, unless you own the business, you don't know where they're going to send you. They may need you one day in Guadalupe to lay foundation. They may need you one day in Bexar County to put up framing. They may need you one day in Travis County to do tape and float. So my question is, if he's given set hours, let's say, for example, it's Monday through Friday, 7 a.m. to 7 p.m. Can he pick up the phone, call you? If you're not there, leave a message and say, this is Luis Eduardo Briceño, SID number, give him your SID number. I am going to be at the construction site in Bexar County, hypothetically, 300 De La Rosa. And then you can check on GPS. Either he's at 300 De La Rosa or he's not. If he's not, then that's a violation. Are we able to do that?
Honestly, with that, I would have to staff it with my supervisor because I cannot really say. If the situation comes to, then, and if my supervisor agrees to it, then yes.
Okay, all right, just a moment. Can you raise your right hand? Do you solemnly swear or affirm the testimony you give would be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record. State your name for the record.
Oh, Luis Eduardo Briceño.
All right, what is your work schedule?
7 to 5 or 6, it depends, 12 hours.
So you're saying 7 a.m. to 5 p.m.?
Yes, ma'am.
What days?
Monday through Friday, Saturday, overtime. And it's the one I had, it was overnight. It was gonna be night shift, so from 6 to 6 in the morning.
All right, this is what we're gonna do. I'm gonna allow him to work because he's already allowed to work because he's on partial. He's gonna be allowed to work from Monday through Friday, 7 a.m. to 5 p.m. You should have some idea if they're gonna want you to work the graveyard shift. You should know that. I know that much about construction.
Yes, Your Honor.
If he's gonna work the graveyard shift, then counsel, you'll have to send notice to the court that he's working the graveyard shift in the terms of a motion.
Okay.
I will sign it. And then you pick up the phone, you're gonna call your pretrial services officer, and you're gonna say, again, this is Luis Briceño, SID number. I am working at construction site at 300 De La Rosa. You understand?
Yes, Your Honor.
And guess what? If nobody answers, usually a recording will come on. Leave a message. I know sometimes it gets frustrating for people. You don't want to leave a message, but guess what? If you don't leave a message, you didn't call. Do you understand?
Yes, Your Honor.
Is everybody on the same page?
Yes, Your Honor, but may I be heard briefly?
Sure.
Judge, this pretrial services officer is the only pretrial services officer who has ever called me to verify that my client was physically present for a consultation that my client had approval to be at. He gave us a hard time because we ran a few minutes late. That was my fault. I have an email here where my client asked to go do laundry and go to the HEB a day ahead of time. And the only response from this pretrial services officer was an email back that just said denied.
All right. So here's the
Restriction's
thing.
been extremely difficult. So we just asked it
Well,
to be removed from the partial.
No.
I should also tell the court, this is not a family violence case. It's going to be transferred back to CTD.
Okay. No, this is what we're doing. What we are doing is exactly what I said we're doing. He's on partial for work only. If he wants to go do his laundry, if he wants to go to HEB, then that's a motion for another day. We are just partial employment. And this is the court's ruling. Monday through Friday, 7 a.m. to 5 p.m. Understand?
Yes, Your Honor.
If it's going to be overnight, you need to let them know, and counsel, you need to file a motion. That's where we are.
How about if it's on weekends and how?
You need
file a
to,
motion.
you need to file, he'll have to file a motion, and you should know about that before the weekend comes.
Yeah.
And again, you need to pick up the phone, leave a message and say, this is the location. All right, we're all adults here.
Yes, Your Honor.
Everybody treats everybody with respect. I do understand, and I'm ordering, do I need to order everybody to treat everybody with respect? Okay, I'm ordering everybody to treat everybody with respect. Even if internally you don't respect the person, outwardly respect the person. So if you are going to be late, pick up the phone, leave a message with Mr. Garza. This is Luis Brasenio. This is my SID number. I'm running late. I'm still at the work site, and GPS will show that you're still at the work site. Do you understand?
Yes, Your Honor.
I understand because I see both sides, right? I understand he's calling, verifying you that you're still at your attorney's office.
So this was 30 minutes in, Judge.
Here's the thing. This is where we are, people. We're starting off at ground zero. I've given everybody my orders. We're gonna follow through with that. Nobody here's a toddler. You know, I'm learning from my niece that toddlers have demands and you need to answer those demands. But so what we're gonna do, Monday through Friday, 7 a.m., 5 p.m., he's allowed to work. Even though I'm allowing you to work, on Monday, when you go to work, if you know you're gonna be at 300 De La Rosa doing construction, pick up the phone, call Mr. Garza. If he's not there, because you're not the only person he's supervising, pick up the phone, call him, leave a message, state your name, your SID number, and I'm at 300 De La Rosa doing construction. You understand?
Yes, Your Honor.
If they send you to another construction site midday, your name, SID number, Mr. Garza, I've been moved to 200 De La Rosa to do construction. Are you able to do that?
Yes, Your Honor.
All right. So that's what we're going to do. And here's the thing that I want everybody to understand. Everybody has a hard day. There are some days where you meet people at their job, and guess what? They've had a hard day and they're taking it out on everybody, and their patience is non-existent. I always try to have patience, and even when I'm having a hard day, I just smile, because you know what? Once you smile, that makes the day better.
Yes, Your
Now,
Honor.
see, your problem has been solved. And then if you want to do the HEB and all of that, that's for another day. Let's solve the problem before me now, and we'll go from there. Now, Mr. Garza, we're off the record. Mr. Garza,
Yes, Your Honor.
is there an email that you maybe want his attorney to send an email saying where he's at as a follow-up, or is just his calling enough?
I would be preferred to be either or, both call and an email. Mr. Briceño does have my email address.
All right, so Mr. Brasenio, are you able to email through your phone or no?
Yes, Your Honor.
All right. So then that's what we'll do. And guess what? Having an email, that's good for you because that's a paper trail. All right.
Mhm.
All right. So I am going to order, you're going to be allowed to work Monday through Friday from 7 a.m. to 5 p.m. And if there is a weekend issue, council, just send me the motion if he's working on the weekend.
Sure, and for the further bond conditions that the writ that we're gonna file, can we get a setting today, or would you prefer for me to wait for the writ?
Oh, you have to follow it.
Okay.
Okay. All right. Is there anything else?
I was just asking if we could calendar it so I know when to set it.
Oh, no, you can set it with Ms. Ferguson.
Okay.
All right. Is there anything else?
No, would Mr. Garza mind sending me an email directly to my email, which he should have, but it's Joe, J-O-E, @hgclaw.com. And also, would he mind if I asked, does he speak any Spanish? It might help with some of our communication issues.
Yes, I do speak Spanish.
All right. Are you a Spanish speaker?
Yes, ma'am.
Oh, okay. All right. All right. If there's nothing else, then that will be that. Okay. All
Thank
right,
you very much. Thank you.
Thank you, Judge.
Welcome.
I have signed a few of them at this point,
All right. So has there been any new discovery?
not to my knowledge.
All right. So you can make sure that the acknowledgement of discovery, the state actually has it and the court has it, because it's not in the court's file. And Odyssey is doing things on its own. So I'm gonna have y'all come back tomorrow. You're not number one on the docket.
Okay,
There are a couple of cases that are ahead of you, so those cases may end up going before yours. We'll just see where we are, okay?
that's correct.
Respectfully, Your Honor, Mr. Rios always appears, always waits all day. This is impacting his employment. We would ask that if we're not likely to be called tomorrow, that we be released. Additionally, I have experts for this trial that we have attempted to bring in, but we never know, and because the case is older now, when we should bring those experts in. So I'm gonna have to approach the court and request additional funds for those experts if we're reset. So I would ask the court either to give us some preference tomorrow for trial, or if we can't do that, to release Mr. Rios so that he can go to work.
All right, be here exactly at 9:30, okay?
Okay, yes,
All right, I'll supposed to be here exactly at 9:30.
You understand? Now, Your Honor, respectfully, every time we come to court, we lose an entire day of work ourselves too. This is not typical of most of the courts in this county.
Oh, yeah, it is very typical.
It's not.
Yes, it is.
You can say that, Judge, but I practice on
And
the
say that.
courts.
And it very is typical, because every attorney that's here has a case that's set for jury trial. And this is what ends up happening. What ends up happening is I will allow people to go to civil cases to be out of county, and then their client is sitting here waiting for them. And for some reason, that's the court's fault. That's not the court's fault when attorneys are not showing up at 9 or whatever, and then they stroll in at 9:30 or 9:45. So what I'm telling you all, 9:30, see y'all at 9:30. Thank you. Coordinator will give you a reset form.
Understood, Your
All
Honor.
right,
I'm
thank
trying to make
you.
a record. I don't see the court reporter typing.
What?
Okay, so we only take a record in this court when the judge tells you to? The case was called.
No, the case wasn't called. When I call the case, I call it by the style of the case.
Okay.
All right? All right, so I'll see y'all at 9:30.
Judge, I have to ask you, is this a tactic on the court's part to attempt to wear out the defendant so they can't access their right to trial?
Oh. I find that very inappropriate to say when there is no proof and people are just throwing things out. Now, what I can tell you, and I'm sure your client is aware, sometimes when we end up coming to court, we come to court because there are discovery issues. Sometimes when you're in court, you are in court because your attorney is late. And when I say late, I mean that when a case is scheduled in this court and it's scheduled for 9 a.m. and attorneys go to different courts because they want to go to different courts first, it is not the court's fault that you're sitting here for 12 o'clock or 1:30 or coming back over break. Number one, I have a lunch break. And there was a point in time where I would not take a lunch break. And the reason why I wouldn't take a lunch break is because I said, you know what?
Make a record?
I've been a defense attorney. And when I was a defense attorney, what I would always do, I'm like, I have to be in like 5 courts. It would be nice if they could stagger their docket. And so sometimes I would be here, we wouldn't have a lunch break, and I would be here till 3 o'clock. And then you know what I discovered? When I would say that I'm going to be here till 3 o'clock, I'm working through lunch, other attorneys, you know what they would end up doing? Then they wouldn't show up in the morning. They would just show up at 1:30 or whatever, because they're like, oh, the judge is going to stay there. So I stopped doing that because I need a lunch break. And that's what happens.
So then my other question, I guess, is if you're not doing this to cause the hardship, it obviously causes on all the attorneys and the defendants. Are you doing this for the YouTube? Because we don't have a record, right? Except for the YouTube.
Yes, here's the thing. You're to be back tomorrow at 9:30. You
Yes.
understand?
Yes.
All right, thank you so much. And once you sign the reset form, you'll be here tomorrow. If somebody goes before you, somebody goes before you. Your counsel is well aware, or should be well aware, if he's been practicing in Bear County,
For almost
that
20
there
years.
are a lot of cases that are on the docket for jury trial. So for example, I had approximately 40 cases down for jury trial today. And what ends up happening, sometimes people who are in custody take precedent because their cases are
I'm
older than
asking for a
yours.
record, by the way.
You understand? Because they're older than yours. So that's what happens. So then what
Links
ends
are
up
being made, there
happening,
should be a record, right?
excuse me, stop interrupting me.
Well, we're not on the
Stop
record,
interrupting me.
right? I mean, we're not in
Stop
court. if there's no record.
Interrupting me.
Sir, here's your reset form at 9:30.
So what ends up happening, sir, is that people who are in custody, sometimes their cases take precedent. And the reason why it takes precedent is because their cases are older and because the jail is overcrowded. Now, as you may or may not be aware, I call the docket all the time at 9 a.m. And sometimes when I call the docket at 9 a.m., defense attorneys are not here. Your attorney knows when he has not been here at 9 a.m. And then you have to wait. And you
Judge,
need
you're
to
aware
be
that every
here.
court starts at 9.
And you need to
I have
be
other
here.
cases.
And you need to be here at 9. So when your attorney is somewhere at another court, you know what ends up happening? Your attorney has made the choice to have you sit here and go to another court before
Well,
coming
that's not
here.
exactly true,
You
because all of
understand?
those courts got
All right,
business
good luck to
accomplished.
you.
All
Thank
of us
you.
got
Thank you,
recalled
sir.
today,
Thank you,
right,
sir.
Judge? So, I mean, what did we
Have a
accomplish
nice
today?
afternoon, sir.
I
Sir,
mean, that's the reason I don't come to your court at 9, because I know in another court,
Sir,
some things
here's your
can actually
reset.
occur.
sir,
And they're courts of exactly the same
Sir.
jurisdiction.
right this way, sir.
Mr. Diaz, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 2?
Yes.
Court would find violation of condition number 2 true. Is there an agreement?
Honor, we do have a good recommendation to enter an adjudication of guilt and to sentence Mr. Diaz to 2 years in the Texas Department of Corrections.
Is that the agreement?
Your Honor, that is the agreement.
Mr. Diaz, are you asking the court to follow that agreement?
Yes.
Are you waiving your right to appeal?
Yes.
All right, the court will follow your agreement. Yes.
Excuse me. Your Honor, we would ask that Mr. Diaz be credited for all the time he has served in this case, which is quite a bit. I think it's 271 days.
All right. So here's my question. What has he done on probation?
Judge, he hadn't done much. To the court, I'm sure he's an absconder. Mr. Diaz felt he has mental health, serious mental health needs. Resulting from severe head injuries. He felt he wasn't able to get the treatment he needed for it here in Bear County.
Well, I mean, not really, because counsel, I see that I've heard a previous motion to revoke for him. Now, mind you, this is from 2017. And I know I wasn't on the bench on 2017, so I don't know what another judge did. But I know in this court, I always ask anybody, is there anything that they need that I haven't given them? Is there anything that probation is not doing that they feel that they haven't done. So if he didn't have mental health issues addressed, it's because he didn't ask for it. But we were here on April 28th for a violation of 5 and 15F. And I denied those motions and I said he's enroll in the BIPP within 10 days of release from custody. And he was allowed to work and we were asking, and I put in GPS. So has he done anything since he's been on probation?
No, Your Honor, he did not complete the CIPP. I believe he started the outpatient program, however, he was discharged unsuccessfully. No, we have not received any UAs from him. There has not been any payments for any type of fees.
So he has done nothing. What have you done since you're on probation? Would you like to address the court?
Yes,
All right, I'm going to raise your right hand. The state is going to have a chance to question you. Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
yes, ma'am.
All right, you can lower your hand, state your name for the record.
Alfonso Diaz.
All right, what have you done?
I was constantly going, I did sign up for the BIP program, but they wouldn't let me go without a negative COVID test. I did test positive for COVID and did again the following month. And I did do all of the outpatient program, but I didn't submit a drug test. That's why I was discharged. No, as far as the ankle monitor, they wouldn't take it off of me because they wanted me to pay $200, but you waived the fees and they just wouldn't have it. Me and my probation officer were supposed to talk to you about that. And that never happened.
So basically you have done nothing. Like the easiest thing to do is take a UA. You did not do that. Did you ever take a UA?
No,
All right. So that's something that's easy to do. Am I wrong in that assumption?
you know,
All right. Did you complete the BIPP course?
no, I was never allowed in. I have a proof email. You got a letter for it, an email from the people who do it.
So you're telling me since 2022, you have never been COVID-free to do a COVID exam. And actually, there's a motion to revoke that was issued for you July 20th, 2020. And I granted a BF and issued a judge's warrant because you didn't show up. And I'm sorry, it's April 28, 2021. You're telling me that since April 28, 2021, you never tested negative for COVID to start the BIPP course. Is that what you're telling me?
Judge, I have to say, I've never seen an MPR from 2021. The latest I've gotten is from 1920.
No, he didn't. Here it is right here. I think you were not the attorney at that time.
I believe you, Judge. I'm just
Yes.
saying, in my efforts to get all of the motions to adjudicate and revoke, up until this morning, the latest one I had was from 2018. After being assured I'd gotten everything. Finally, this morning, your clerk handed me one dated from 2020, said, sure me that was the last one. I have not seen them. 2020, the one I have in front of me is the last one I've gotten, and I just got it
Do
today.
you want that, counsel? Do you want more time? Because there's one from February 25th, 2019. And on that motion to revoke, he was not revoked and he was told to do certain things. And from that, and then there's a violation report from 2017, which I didn't consider because I was not the judge at that time.
Judge, I'm not sure it's necessary that I see them. What I do want to disagree with, if I may, is
Mhm.
that your conclusion that he's done nothing. He wasn't able to complete the BIP program because of the COVID problem.
All right, I hear what you're saying, counsel, but you just told me that he absconded.
I just told you that what I intended to tell you was he believed he couldn't get treatment he needed as a result of the serious head injury that he has here in Barrett County. I know that's likely inaccurate, but that's what he believed. Believing that, he elected to go to Massachusetts, where he did get help for that in a number of respects. he obtained a job, which he still has with Walmart for, I suppose it's a union Walmart for $18 an hour as a stalker. He has gotten counseling up
All right,
there.
but we're in the middle of him testifying. So does anybody want to ask him some questions? Because before me, what I have right now is he's done nothing.
I'll ask a question.
Sure.
Mr. Diaz, where have you been living while you've been not reporting?
For the last 3 months in Massachusetts and North Adams,
What brought you to Massachusetts?
to seek help because it's a Commonwealth state, and I was immediately getting help for mental, from my PTSD, and also I've been getting memory issues, so I decided to seek help for my for a neurologist.
So, but that was 3 months. So where were you before that time?
I
period?
was here, I was living in my apartment, I wasn't leaving, I had severe PTSD and severe anxiety, so I wasn't leaving home.
What caused your PTSD?
I was shot at when I was 14, and when I was arrested for the last MTR, I was arrested because I called the police, I was shot at again. And when I was 17 years old here in Bear County, I was beat up while I was here before 17-year-olds were kept away from the general population.
Okay, have you had any contact with the victim in this case, Molly?
No, not so. No.
Do you have a new relationship?
She's the mother of my other 2 children, but it's purely civil.
And how old are your children?
My other 2, 12 and 11.
So you were in Bear County. Did you have a phone?
No, I didn't. No.
Did you have a job?
I had lost my job due to me staying inside too.
Due to what?
Due to me staying inside, it was agoraphobia. I was separating going outside for any reason at all.
So this is what I don't understand. One, these are some questions I have. The first one being, did he have permission to go to Massachusetts?
I don't see anything in the system indicating such.
So we have him going to another state without permission. 2, there's treatment for PTSD here. If it would have been asked for, I would have been ordered. I would have ordered it, and it's not here.
Yeah.
So that's a problem. So what I'm looking at is someone who has behaved as though they're not on probation. And now they're coming to me with excuses as to why I should give them a minimum. And he's had a motion to revoke in 2018. March 2nd, 2018, according to the docket sheet. Then he had another one in November 6th, 2018. And let's say that, I don't know, that judge was like, I'm not listening to you about what you need. I'm not saying that's true, but let's just assume that's true. He came back here July 20th, 2020. A warrant was issued for his arrest. Didn't see him back till April 28, 2021 to address the same allegations that were in the previous motions. And what did I do? I denied it, told him to roll and bip. And he's up here working at a grocery store at Walmart. Well, working at Walmart, I don't know if it's Super Walmart or not. Did you give them a COVID negative test?
No.
All right. So he is trying to tell me, and if this is not what you're telling me, let me know. It appears to me that you're trying to tell the court that you could not prepare or get a negative COVID test since April 28, 2021. And that's why you can't enroll in BIP. So are you telling me that you've had a positive COVID test since 2021?
No.
So he didn't do BIP. He hasn't reported. He left this, not just the county, he left the state without permission. And he's saying he has, PTSD and he can't leave his house, but he sure left his house to go to Massachusetts.
I also left my apartment because there was construction and we got locked in. They lifted the building while we were still in it. So I had no choice but to leave that apartment, and I had nowhere else to live.
Yeah, but I mean, you left with
no-
all of your mental health issues that you're telling me that I don't have any documentation of. You left not only your apartment, but you left and went to an entire different state.
Yes.
And And I'm not a psychologist or a psychiatrist, but I will tell you in undergrad, I took enough psychology courses where I could have majored in it, but I just chose not to because that wasn't a field I wanted to go in. So you're telling me you can't leave your house because of a mental health issue, but all of a sudden, not only do you leave your apartment, which I understand they closed it down, but you're able to get to another state. And how did you get to that other state? Did you take the bus? Did you take the plane?
Drive.
All right. So you drive to an entirely different state. And I'm sure from here to Massachusetts, there is no car that will take you there without stopping at a gas station to fill up. How many times did you stop at a gas station to fill up?
I'm not exactly too sure every 300 miles, but I'm not the one who was getting out.
All right. So you drove there with someone else?
Yes, my wife, my kid.
All right. So he's driving around with his children. So I can tell you right now, I'm not following this agreement because you have done nothing. And to receive the minimum for doing nothing would not be fair. It wouldn't be fair to you to teach you a lesson. It would not be justice. I understand that sometimes people have built a new life for themselves and they want to forget about the past and act as though that never existed, but it did exist. And you have done nothing. So I'm not giving him 2 years.
All right, Your Honor. Given that the case, I've already canceled the witness I was going to testify this morning.
Oh, no, he's already pled true. I'm going to sentence you to 3 years in the prison. Give you credit for any time served. There's an affirmative finding of family violence. There's to be no harmful or injurious contact with Molly, Mollie, Alvarez. All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
You did, Your Honor, under the impression that his sentence is going to be 2 years.
Well, no, because when I asked him, I said, do you understand by pleading true to violation of condition number 2, the court could sentence you up to 10 years in prison and up to a $10,000 fine? And he said, yes. So because this is not a plea bargain agreement, you do have a limited right to appeal, and that right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is an affirmative finding of family violence, and also because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you.
Your Honor.
You're welcome. Carlos Salazar. How long is long?
He has.
Well, they're calling me. They desperately want him in misdemeanor court. I don't understand why people don't understand that there's a hierarchy. And the hierarchy is that district court take precedence over misdemeanor court. District court takes precedent, criminal district court takes precedence over civil court. I don't know why people don't understand that.
Judge, I completely agree and understand what you're saying.
Yeah.
Our witness is out in the hall. He's been waiting.
Oh, well, they've sent a deputy from misdemeanor court to escort Mr. Cox down to misdemeanor court. Yes. And I know it's not the deputy's fault. I don't want to make your job any more difficult than it is, but they've sent her up here to take him to misdemeanor court, where the range of punishment goes as high as 1 year at the Bexar County Jail, where we're dealing with the case here, where he's charged with burglary, which the range of punishment is potentially 20 years in prison, but they want him in misdemeanor court. This is the last time, and I want all the attorneys to go forth. This is the last time that this court will be given any type of leeway for people to be out of county in misdemeanor courts, out of county in other courts when you have a jury trial or a bench trial in district court. The only courts that take precedent over felony district courts are the federal courts. I don't know why people don't understand that. So this bench trial is going to finish today. If we're here at midnight, we're here at midnight. And state, I understand that you say your witness is going to be short, but
Judge.
I don't know if it's going to be short.
Judge, the other issue is that he was taking care of a sick parent. He did ask for leave time and we did get him here, despite him taking leave. So
Huh?
it did take extra effort for us to get him here.
All right. So how long is this witness going to take?
Judge, it's gonna be quick. He has a maybe 15-minute interview and a video. That's about it.
And it's a video of the defendant?
Yes, Judge.
All right. So what are you bringing this witness for? To lay the foundation for the video?
Yes, Judge.
All right. Defense, are you going to have any objections? If this witness has to appear by Zoom, are you going to have any objections to that? Because if you're going to object to that, then I'm sorry, Deputy, he's not going downstairs.
Say having the witness outside, here by Zoom.
Yes, because he has someone who's ill that he needs to be taken care of.
And Judge, I can further explain. He explained it to me this morning.
Okay. Unless my understanding is it's the video and it's the alleged video of your client. Unless you all are going to just stipulate this is the video and then the court can hear any objections. Otherwise, defense, are you going to have any objections to him appearing by Zoom? And Deputy, I realize it's not your fault.
Would like to have the witness here, since he's here.
All right, then, Deputy, I'm sorry. All right, bring the witness in. Call your next witness.
It's an option of either 10 years jail, 10 days jail.
That's outside the plea bargain agreement.
It's in our plea bargain.
No, it's outside.
It is part of our plea bargain.
What I'm telling you, counsel, is this is your plea bargain agreement. This is outside the agreement.
Well, it is my understanding it's part of our plea bargain.
All right, I'm telling everybody, it's not a part of the plea bargain agreement. Note, this is what it reads. Note, the parties are not allowed to make binding agreements regarding the length of community supervision or the terms and condition of community supervision, which are totally dependent upon the court's discretion. The following recommendations do not constitute part of the formal plea bargain agreement. However, the state or both parties make the following non-binding recommendations. And what it says is 5 years community supervision, TAP evaluation, 120 hours of community service restitutions, 2-year driver's license suspension, 10 days house arrest in lieu of 10 days Bexar County jail. That's not a part of your plea bargain agreement. You all can present that to me and I can either follow it or not follow it, but that's not a part of the plea.
Is the 5 years probation part of our?
No, it is not. The court
So-
determines the length of a probation.
And if you reject that 5 years, then it's a rejection of the plea bargain agreement.
No, if I don't follow your length or your suggestion for the length of probation and I give you, let's say I were to give you 8 years on probation or 4 years on probation, that's not a part of your plea bargain agreement and I have not violated your plea bargain agreement because the court determines the length of probation, not attorneys.
Then Judge, I think we can't go forward with this because our understanding of what a plea bargain agreement differs.
All right, well, what I'm telling you all, according to the law, you cannot come before the court and tell the court, I want to be on probation for 5 years only. Y'all are not allowed to enter that agreement, period.
Now, Judge, you do not have to follow that agreement. That is correct.
That is not a part of your plea bargain agreement, counsel. The court decides the length of probation that somebody is on. The attorneys do not. The attorneys just make a suggestion. I'm going to read it again. Note, the parties are not allowed to make binding agreements regarding the length of community supervision or the terms and conditions of community supervision, which are totally dependent upon the court's discretion. The following recommendations do not constitute part of the formal plea bargain agreement.
Is probation
then-
part of the agreement?
Yes, they're recommending probation. Now, if, for example, if I were to say, okay, you guys have agreed that he's to have probation and I say I'm not giving you probation, then I will have violated your plea bargain agreement. But the length of time, the conditions, that's completely up to me. The court does. So if I want to give, if the state is asking for 8 years probation as the length, I can say, you know what? I've read the facts of this case. I think the person should only be on probation for 4 years or 3 years. That's up to me. Or the state may say, me and the defense counsel believe the person should be on probation for 5 years. I may read it and think, no, that person should be on probation for more than 5 years. I'm allowed to do that. And guess what? That is not going against the plea bargain agreement that you've entered to. So if y'all want to discuss that, you can. But if other judges are saying, oh, the law is that's the plea bargain agreement, then those judges would be wrong. All right, yes,
I'm not ready to go forward with it then.
then we'll be in jury trial. All right, Macy Malone.
Present.
All right, so did they give you, and if you want to hand that back. So jury trial is at 1:30. And you can put that in here. All right,
Well,
Macy.
we're announcing not ready on the trial because we were expecting
Oh, you all need to file a motion. I'll hear it and make a ruling on it.
Okay.
All right, Macy. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty and the court will find you guilty. Are you proceeding with sentencing?
yes, Your Honor.
Anything you wish to say on behalf of your client?
Well, you had an ignition interlock on the car?
Okay, you're all gonna have to speak up so that the court reporter can hear.
And have you been abiding by the conditions of bond and
Yes, sir.
not drinking alcohol?
No.
You want the judge to grant you probation or to continue you in with the ignition interlock for 1/2 of the time?
Yes.
All right, do you have any children?
No.
Are you employed?
Yes.
What do you do?
Electrician.
And how long have you been doing that?
About 10 years.
All right, do you own your own business or you
I
work
work for a
under?
company.
I'm sorry?
I work for a company.
Okay. All right. This is what the court is going to do. The court is going to sentence you to 5 years in the prison, suspended and probated for 5 years. There's a $500 fine that will be probated. There's going to be 90 sober meetings in 90 days. With regards to the Bexar County Jail or GPS, 1 or 2 ways. Either you can go to the Bexar County Jail, do your 10 days, or either you will be on GPS for 30 days, partial for work, and it will be only for work. Or either if you don't want to do work, you can be on full house arrest for 20 days. Which do you prefer?
I go to work back to
All right.
GPS.
So because of you, it appears you have on a mask.
Yes, sir.
So because of health issues at the jail, the court will grant you to do 30 days GPS, partial for work. All right, we can go off the record. In this court, communication is key to be successful in probation. If there's an issue, let probation know. If you feel like they're not addressing it, you can always come back to the court. Do you understand?
Sure.
All right, good luck.